This is a CMRE financial video. Hi, I'm Consumer Protection Attorney Bill Clanton, and I've helped hundreds of consumers deal with debt collection harassment, inaccurate credit reporting, and other consumer-related matters. In this video, I'll be discussing CMRE Financial Services, who they are, where they are, what they do, and the laws that apply to them. CMRE Financial Services, or CMRE, is a third-party debt collector. They are a legitimate debt collector. They are based in Brea, California. They've been around since 1974, so they're about 45, 46 years old at the time this video is made. They have a bond on file with the Texas Secretary of State, so they are a legitimate established debt collector. And they specialize in collecting health care debts, medical bills, hospital bills, and other related types of health care obligations. Medical debt is a consumer debt, and so CMRE is regulated by consumer protection laws. Medical debts are widely considered consumer type debts. And CMRE has been complained about and has been sued for violating these laws that protect consumers from consumer debt collection harassment and credit reporting. At the time of this recording, there's over 40 complaints with the Better Business Bureau about CMRE. The Consumer Financial Protection Bureau reports over 1,000 complaints with them about CMRE. And according to federal records, there's over 150 lawsuits on file against CMRE. So what are these complaints about? What are these lawsuits about? Well, what do people complain about? Well, being harassed by CMRE and their debt collection efforts. There are 3 laws that apply to CMRE, generally speaking, as far as consumer protection goes. The primary amongst these is the Fair Debt Collection Practices Act, or FDCPA. Another law is the Telephone Consumer Protection Act, the TCPA. And the third is the Fair Credit Reporting Act, or FCRA. These 3 laws protect you from CMRE. Under the FDCPA, CMRE cannot lie to you. They cannot harass you. They cannot abuse you. They cannot threaten you. It's a violation of the FDCPA if they threaten to take an action that they do not intend to take or they cannot legally take. If they use profanity or obscenity, it's a violation of the FDCPA. If they lie to you about the amount of the debt, the character of the debt, or the legal status of the debt, that's a violation of the FDCPA. If they fail to report a debt is disputed after you dispute it, that's a violation of the FDCPA. The FDCPA says they cannot add any fees or collection costs to the debt unless that's provided for in the original agreement establishing the debt. Under the FDCPA, CMRE is required to send you a letter when they start collecting the debt. It's as part of their initial communication or within 5 days of their initial communication with you. This letter has to state who you owe the debt to, the amount of the debt, and it has to give you information about your ability to dispute the debt and request verification of the debt. If they fail to give you adequate notice of your rights, or their notice is confusing or inaccurate as far as the amount or who you owe the debt to, then these can all be violations of the FDCPA. These letter violations can be in subsequent letters as well. It's always important to compare the amount they say you owe in a collection letter to the amount they're reporting on your credit report. If these two are different, then there could be a violation of the FDCPA or the Fair Credit Reporting Act there. Before I talk about the Fair Credit Reporting Act in more detail, another law that applies to entities that use auto dialers is the Telephone Consumer Protection Act. CMRE, if they use an auto dialer, has to follow the TCPA. The TCPA says that CMRE when they call you with an auto dialer, has to have your permission to dial your cell phone number. If they don't have your permission, it's a violation. If they do have your permission, they can call unless you revoke that permission. Revoking permission is very simple. When they call you, say, "This is my cell phone, please stop calling me at this number," and they have to stop. A violation of the TCPA, the penalty for the violation is $500. And if you can show that they violated the TCPA knowingly or willfully, the penalty is up to 3 times that, or up to $1,500 per call. The damages in a TCPA case can add up very quickly. Now back to the Fair Credit Reporting Act, the FCRA. The FCRA requires that CMRE report information accurately and completely on your credit report. If they fail to do this, and you write them a letter disputing what they're reporting, they have to correct it. If they fail to correct it, then you have a cause of action or a case under the Fair Credit Reporting Act. These are all powerful, very powerful federal laws that protect you. Protect your reputation, protect you from being harassed, protect you from getting unwanted calls. But I can't put them to use for you until you give me a call. I will evaluate your case for free. The Fair Credit Reporting Act and the Fair Debt Collection Practices Act say that they'll have to pay my attorney's fees at the end of the case. The TCPA cases are taken on a contingent basis. I'll evaluate your case for free. I won't charge you anything to file your case and to fight for you against CMRE. But I can't start that fight until you give me a call. My number is 210-226-0800. Call today. Put an end to it. You've got nothing to lose. Thanks for watching this video.